second accused. Ms. Waweru is only brief for Katwa Kigen for the third accused. Mr. Michuki Kevin is appearing for the fifth accused person. Professor Ben Sianya, together with Mr. Ugaro, appear for the LSK, interested party. Ms. Nyambegi is holding brief for Ms. Muchemi of ICJ and Senior Counsel Ojambo for the victims.
Sorry, you said Miss?
Ms. Nyambeki, holding brief for Ms. Muchemi and Senior Counsel Ojambo for the victims.
So those are different. We have victims and we have IJM. So you are holding for?
Yes, my lady, I'm holding brief for both.
For both?
Yes, for both. The matter is for sentencing, and we are ready.
My lady, before the quorum is completed. Good morning, my lady.
Happy New Year.
Happy New Year. Happy 2023.
I not seen it.
The president of LSK, Mr. Eric, just coming and introduce team that is.
Sorry about that, my lady. I have not seen the president of LSK.
The vice president, I'm also told, is.
I think the president is enough.
I stand guided, my lady. Thank you, my lady.
So happy New Year to everyone. Will the accused be upstanding? I'll not read the entire ruling. I'll just read the part of it. The rest of it will be obeyed later. So the accused persons who are Frederick Oleleliman, hearing after the first accused, Stephen Cheburet Morogo, hearing after the second accused, Sylvia Wanjiko Wanjohi, hearing after the third accused, and Peter Ngoge Kamau alias Brown, hearing after the fifth accused, were convicted of 3 counts of murder contra Section 203, as is read with Section 204 of the Penal Code. Section 204 of the Penal Code provides that any person convicted of murder shall be sentenced to death. Now, the sentencing principles. Now, the Penal Code provides under Section 203 that any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. And then Section 204 of the Penal Code provides that any person convicted of murder shall be sentenced to death. The Court of Appeal, and indeed the High Court in several petitions and criminal cases, have made various pronouncements on the issue of murder and the death penalty. They grappled with the issue whether the death penalty should remain as a sentence under our penal laws. Now, some of these cases were the Godfrey, Ngodo, Mutiso, and versus Republic, and then Joseph Njuguna, Maura, and 2 others versus the Republic. Those are Court of Appeal decisions. So the decision of the 3-judge bench in Ngodo Mutiso was declared per incuriam by the 5-judge bench in the case of Joseph Njuguna Maura and 2 others versus the Republic, insofar as it purported to grant discretion to courts in the exercise of sentencing persons faced with murder charges. The issue of the death penalty, its constitutionality and application under the new constitutional dispensation is now settled. The binding judgment of the Supreme Court in Francis Kariuko, Muruateto, and another versus Republic, where the court made the following order. that is Order G, paragraph 112 of the judgment. They say that accordingly, with regards to the claims of the petitioners in this case, the court makes the following orders. A, the mandatory nature of the death sentence as provided for under Section 204 of the Penal Code is hereby declared unconstitutional. For the avoidance of doubt, this order does not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution. Now, prior to making that order, the Supreme Court made the following guidelines, and I quote, as a consequence of this decision, paragraph 6.4 to 6.7 of the guidelines, that is the sentencing policy guidelines of the judiciary, are no longer applicable. To avoid a lacuna, the following guidelines with regard to mitigating factors are applicable in a rehearing sentence for the conviction of a murder charge. Now, A, age of the offender. B, being a first offender. C, whether the offender pleaded guilty. D, character and record of the offender. C, E, commission of the offense in response to gender-based violence. F, remorsefulness of the offender. G, the possibility of reform and social readaptation of the offender. And then H, any other factor that the court considers relevant. We wish to make it very clear that these guidelines in no way replace judicial discretion. They are advisory and not mandatory. They are geared to promoting consistency and transparency in sentencing hearings. They are also aimed at promoting public understanding of the sentencing process. This notwithstanding, we are obligated to point out here that paragraph 25 of the 2016 Judicial Sentencing Guidelines states as follows. That is a quote, guideline judgments. Where there are guideline judgments, that is decisions from the superior courts on a sentencing principle, the subordinate courts are bound by it. It is the duty of the court to keep abreast with the guideline judgments pronounced. Equally, it is the duty of the prosecutor and defense counsel to inform the court of existing guideline judgments on an issue before it. Now, the circumstances of the offense. In respect of the first accused, the evidence adduced before this court was proof that the murder of the deceased was premeditated and that it had been hatched by the first accused who was the master plan several days before the date of the execution of the plot. Now, the conspiracy involved high-level planning and organization, meticulously carried out. It involved sophistication and the use of technology with mobile phones and police radios. On the material morning, the victims' movements were monitored in and around the courtroom at Mavoko Law Courts. Eventually, they were trailed, abducted, and ferried in the abductor's vehicle, that is a private car, to a container at Syokimau AP post. They were locked up at midday and detained until nightfall without food or water. From the circumstances of the offense of the case, the following are the aggravating circumstances or factors. 1, the murder was intended to interfere with the course of justice. 2, the offense was committed by a group. 3, the deceased were kept inside the boot of a car and taken out one at a time to be murdered. The murder was executed close by so that the victims could hear the thumping and blows being inflicted and the screams and shouts or groans of their colleagues as he was killed. The fact each knew they would be the next to face the same fate, this must have caused them extreme fear, stress, and psychological torture, that is to the victims, as they waited for their turn. Now, 4, crude weapon was used to batter the victims to create the excruciating pain to the victims. 5, the deceased were put in gunny bags and plastic bags and dumped into the river with the intention to conceal the murders and make the recovery of their bodies difficult. The murder involved flagrant and excessive use of violence on the deceased and caused damage, of course, to their persons. 7, the first accused, while he clearly had a grudge against the deceased Mwenda, he captured and killed the deceased Kimani and the deceased Mwerori, not caring about their lives and the fact that they had not done anything to him to deserve what he did to them. They were collateral damage, and I must add that not that Mwenda deserved the judgment that he received from them either. Now, the first accused, being a police officer who had been employed and paid a salary with public funds to protect life and preserve property, acted in flagrant abuse of his office and acted contrary to the duties and responsibilities he was employed for. Now, also the offense involved detention and inhuman treatment of the deceased persons. Now, the issue of culpability, the first accused shot the deceased Mwenda 1 year before the incident, which is the subject matter of this case, even though the injury was very severe, being a gunshot wound that involved the hand and the upper chest. The first accused, after taking him to a clinic for first aid, took him to the Mavoko police station, where he locked him up in the cells for 3 days before charging him in Mavoko law courts with several criminal charges. That was the beginning of a prolonged and sustained harassment against the deceased Mwenda, until out of sheer fear for his life, he approached International Justice Mission, that is IJM, and Independent Police Oversight Authority, that is IPOA, for help. And he got help because IJM gave him a lawyer to represent him in court, another lawyer to act as his bodyguard, and every time they went to court, a taxi to ferry him to and from the court. In the meantime, the report Mwenda made with IPOA gave fruit, because eventually the authorities summoned the first accused and other police officers to make statements in regard to the complaints. It is the commencement of the investigations by IPOA that triggered the delicate and meticulous planning of the murder and the eventual execution of the deceased. In that regard, I have considered that the first accused mounted a sophisticated master plan which saw him capture the deceased Mwenda together with all those who are helping him on the mid-morning of the material day. The first accused was acting out of self-preservation when he planned these murders. His was a personal vendetta against the deceased Mwenda for reporting him to IPOA. The aim, of course, was to destroy evidence by destroying the complainant, which was not only drastic but draconian and an extreme action to take. For the second accused, he stood by his colleague, the first accused, and stuck with him in every step on the material day. The judgment speaks for itself in this regard. He did not have any personal vendetta against any of the deceased. However, he played the critical roles of abducting and holding the deceased at his police station or police post, where he was a senior officer in charge of duty. Now, for the third accused, her role was to keep the deceased persons at the police post, where she was the sentry and report officer, all the way until the time that the deceased persons were removed from the post and taken away to be murdered. I have been asked to consider that she was the youngest and the most junior in the group, and even though not requested, I've also considered that she was the only lady in the group as well. Now, being a police officer with firm, stringent pecking order system, and being junior has significance in the need for discipline and order in the force. That discipline and order cannot include aiding, abetting, and enabling crime, and eventually concealing and denying any knowledge or involvement in it. Had she been candid at any stage of the investigations or the trial, which could have been it could have been a factor that could serve as a positive extenuating circumstance in mitigation. I noted also that even in the mitigation by her counsel on her behalf, she denies playing any role in the matter, However, to her credit, she was candid to the police probation officer and admits negligence in her place of work on the material day that was facilitative in nature. She played a role which is not peripheral, as Mr. Keegan suggested. For the fifth accused, he made a confession to the police, which I believe helped immensely in the investigation. It was his confession that shaped the investigations. His defense under oath was a further confession of his role in the whole murder. I noted the variations in his confession to the police and his confessions in his defense. He did not color anything white that was black. Now, I have carefully considered the mitigation of each of the accused persons as given orally and in writing, and part of which I have summarized in this ruling. I have also considered the various reports that were filed, the probation reports, medical report, the victim impact reports, as well as the certificates of the various courses undertaken by the accused persons during their incarceration. I have also considered the circumstances of this case, the meticulous planning, implementation, and the brutal execution of the deceased. To say the least, this was a most foul murder, an execution that was most heinous. I find that the most suitable sentence for each of the accused persons is as follows. The first accused is sentenced to death in each of the 3 counts. The death sentence in counts 2 and 3 are held in abeyance. Now, the second accused is sentenced to 30 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The third accused is sentenced to 24 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The fifth accused is sentenced to 20 years imprisonment in each of the 3 counts, with the prison terms running concurrently. In computing the sentences in paragraphs 2, 3, and 4, that is in respect of the second, the third, and the fifth accused, the prison authorities to take into account the period of each of the accused have spent in custody during the pendency of this case. I also want to inform the accused persons that they have a right of appeal against both the conviction and the sentence within 14 days from today's date. So those are the orders of the court. I think I'm done here, so I want to say thank you to all those who are involved in the matter, and I wish you all the best.
My lady, from the bar, I've been here for 6.5 years. It's almost whatever lifetime in the bar for something. So if you grant us just 2 minutes, I know you're not.
No, I am now funked as official, Mr. Professor.
You could just listen.
You just want me to listen?
Yes.
Maybe probably before you hear him out, there were some rulings that you want to give in relation to the motor vehicles and the phones. We had asked about that last time. And there was an application that had been made by the prosecution. They are objected to our application.
Yes.
And we insist that we still want the motor vehicle and the phones that were taken from the accused persons. We would also be asking that we furnish the full proceedings, including the sentencing, so that we can be able to lodge an appeal. We shall do this.
My lady, on our part, for the fifth accused, and as I think I can describe myself as a ward of the court, having been appointed to and I did my stuff.
You are a what of the court?
I am an officer of the court. I'm also
you come
a ward of the court because
you come out with very interesting terminology. So what is yours?
Yes, my lady, I just wanted you informed me to request personally from the court that the order that had applied to Ms. Kenyani should also apply to myself with regards to representation for the fifth accused person.
So, Mr. Michoke, my advocate, as you have said, what is it you are requesting? So that I can now put it on in writing.
My lady, I'm just requesting. I didn't want to say the word, I'm just requesting my payment in not so many words. Given the many years that we have undertaken this task, we thought.
I don't know. We did not make any orders in the past.
There might have been an order, but I think it was overtaken by events or not considered.
Kenneth, I know you are with me part of the time. Did you make some order about his payment? We have not made. So you want your payments as per the 30,000?
No, my lady, I was asking the court to vary that to take in the previous order that you had given with regards to Ms. Kenyori, the previous advocate.
I'm not sure whether that is the one I'm remembering. Kenneth, did they implement it? She just got 30,000.
No, my lady, it was implemented for my colleague.
But is the one who is with the books and things. So she told you?
Yes. Off the record.
On the record, I'm being told it was not.
Yes.
On the record, I'm being told it wasn't.
No, my lady, because this matter actually began before the...
No, I'm talking about Mrs. Kenyori.
Mrs. Kenyori. It was before Mr. Kenneth came into the matter. It was during Ketonga's time.
No, I know that, but he was also around.
Okay.
Yes. Do you know about Mrs. Kenyori with certainty? Okay.
My lady, then in that case, you can have both payments paid in kind for me and for Ms. Kenyori.
No, you are not representing her. Yes.
If I may, on behalf of the third accused,
I don't know your name for
Miss
the
Mavoko,
record. Sorry?
Miss Mavoko.
Oh, yeah, the lady who has been coming.
Yes, my lady.
Yes.
I'm calling brief for my learned senior, Mr. Castro. On behalf of the third accused, we pray that her mobile phone should be released. And for purposes of the appeal, my lady will pray for a certified copy of the judgment and the sentencing.
Anything else?
This has been session years. And once again, we want to thank you and the entire judiciary. Want to thank you and the entire judiciary.